Hello, everybody. Welcome to the Meeta and Tosh show, the weekly live business Q&A session. And that's not Meeta, in case you're wondering what's happened. Today we've got Camilla Whitehouse from Gainsborough Law. How are you doing, Camilla?
I'm really well, thank you, Tosh. Enjoying the nice weather in nicer, warmer weather today. So yeah, how are you?
It does look nice there. Good, yeah. Real good. Thank you for doing this at really short notice, actually. Meeta couldn't make it today because of a half term. And so we thought, well, you know what, let's see if I can get you involved. And I know how helpful it would be for a lot of the people that watch us because, this is a live business Q&A session. The idea is to deal with situations or challenges that people are facing. So, and the forum works like this for anybody that hasn't been here before. We've got a chat on the side there on the box. If you've got any questions as we go through this session, and this will be 30 to 40 minutes tops, please put them in the chat. The promise we always make is to answer every single question during this live Q&A. And if for some reason we miss a beat or we run out of time, then we always promise to do a follow-up. If you feel shy to ask a question or there's some more details that you want to put to us, then take it offline. I'll happily speak to you directly or put you in touch with Camilla. Camilla's details will go out with this replay. And if there's any way we can help, then we will do. The other thing I wanted to say is connect with Camilla on LinkedIn and myself. There's lots of information that goes out there that's really helpful to business owners. It's not just legal stuff, it's practical stuff or problems you're facing. And it's got to be day to day, or it's got to be legal cases or disputes or problems you're having. There are lots of solutions out there that aren't perhaps as difficult as you think they might be when you're just thinking about them on your own, right? So before we get going into this, Camilla, we've got a poll, and I'm going to publish that now. And the poll is basically saying, look, what's your biggest frustration about lawyers? Because I think it's a really good idea to kind of get past the myth of a certain perceptions of what's involved when you're instructing a lawyer. So the options we've given you there are number one, fees. Is it number two, over lawyering, lack of communication, legal jargon? Number three, is it just lack of responses? You're giving them a call and they're just not getting back to you quickly enough or promptly enough? Or is there something else? And if there is something else, put it in the chat. Also, as I say, this is an interactive session. So, look, you've got a barrister here and a solicitor here who will absolutely be love to answer any questions your problems we're dealing with right now. And we will do it, as I say, live during this session. So I'll come back to that poll in a minute. So, Camilla, look, before we get stuck into this, and just so everybody knows, we've got 4 takeaways from this particular webinar, but there's a lot more what we want to give you. So the first thing we're going to be covering is what you need to know so you don't even need a lawyer, actually. The second thing is what to do early on to save you time, money, and hassle, whatever the situation. Early on might be preventative, or early on might be, look, you're already in the mud, or there's a court case, or there's, you're getting some problems from somebody, whether it's a director or an employee, and it's still not too late. What is the time to contact somebody then? And when is the right time to engage a lawyer? And there's different ways you can engage lawyers, and also different types of lawyers that might suit you in different types of situations. Camilla, before we get into the Q&A session, tell everybody a little bit about yourself. Tell us about what your experience is and how it is that you help your clients.
Well, I'm a barrister. I was called to the bar about 10 years ago. I think we're 11 years now. And I deal with a variety of commercial and employment disputes. So I practice in a chambers. I wear, I'm not obviously wearing my wig and gown today, but that's what I'm entitled to do. And in 2017, I was dealing with a lot of clients directly. So there's a scheme that allows members of the public to instruct a barrister directly without having to have a solicitor in as an intermediary. And I was having a lot of those. Yes, it's called direct access. And it's quite a revolutionary scheme. I think it's a really helpful one for the right type of client. And I was doing a lot of that kind of work. And then in the end, I ended up setting up my own chambers, Gainsborough Law, in 2017 to kind of tailor it towards helping clients directly. So the Gainsborough Law kind of went from strength to strength. We've expanded, we've taken on more barristers, obviously a lot of support staff and, paralegals who help. And that's where we are. So my practice is totally mixed. I have a variety of clients that come to me directly, businesses and individuals. And I also have solicitors like Tosh who will instruct me as well. So it's about 50-50 split between direct access, so people who are instructing me without a solicitor, and solicitors as well. And what happens as well is sometimes there are situations where I can't help somebody directly, and then obviously I will say to them, look, I'll see if I can help them find the right solicitor for them.
I mean, the types of props. So Camilla, I've been working with Camilla for actually astute law is 10 years. I think we've been working together for 9. And Camilla's been working on various cases with us. You've been within our organisation as a consultant as well. Yeah. So we've been through the mill for quite a while in all sorts of different types of cases, whether they are commercial disputes, company law issues, or employment law issues. So let's get stuck in to our list of topics. And what I really want to be able to give people is an understanding of the kind of problems that we can help solve. And actually, a lot of it is, there's a myth about the way sort of lawyers deal with things, or problem lawyers. Maybe not. Maybe it's a reputational thing as well. So just understanding that there are people out there that can actually really help with those sorts of problems. So I think the first thing I'd like to talk to you about is what in your opinion, I've got a pretty strong opinion about this, is it that clients, what do they need to know so they don't even need a lawyer? Why do people need a lawyer? Apart from the obvious one about the law, why do they need a lawyer in your view?
I think the number one reason I can think that springs to mind is that people bury their heads in the sand. When there's a dispute brewing, instead of tackling it head on, they hope that it's going to go away on its own, and they don't respond to communication in a timely manner, and they just don't engage in sort of any meaningful way with the dispute that's kind of occurring. I would say that's the number one reason.
What I've always found is that, unfortunately, people only contact a lawyer when they've gone through the mill. So they've already felt the pain of it. I suppose that's human nature, isn't it? It's like anything. Absolutely. I don't really need that insurance policy. And so,
you try and do your taxes yourself. You try and do your taxes yourself. Yeah, I can't be doing with this. Yeah,
exactly right. So what we're trying to do is to give a bit of a crystal ball into situations if you already haven't faced these type of situations.
Yeah.
And in our world, they relate to situations where you are dealing with an employee problem. That can be anything, right? That it's a problem caused at work by an employee. Maybe you're firing them, or maybe you're disciplining them, or maybe they're taking you to court. All those sorts of things. In Camilla's other world of commercial disputes, maybe it's a director dispute or a partnership dispute or something of that sort of nature. So, in those situations, the only reason actually, if the truth be told, why you need a lawyer, is just because we know the rules of the game. And what are the rules of the game? In employment law, the number one thing I've always found, Camilla, is people have a difficulty, employers and employees, with understanding that actually in employment law, it's going to sound terrible as it comes out of my mouth, it isn't about the truth. So, the burden of proof in criminal law is beyond a reasonable doubt. Employment law is a balance of probabilities, which means what does it look like? Can you talk to us a little bit about that? Which is why, on a balance of probabilities, it might not be what's really happened, but that's the way that the courts look at it. Can you talk a bit through that?
Yeah, I mean, that's absolutely right. It's really, it's a sad thing, but it's true. What we're looking at in terms of disputes are what can we prove. If it has to go to a determination by a member of the judiciary, a tribunal or an independent judge, then it's about what the parties can establish in law and evidentially. And that is a very different thing to what actually happened, unfortunately. So, but I think the problem, what I notice a lot of people think, and this is absolutely wrong. So there's the balance probability. So you have to establish something, 51% is it happened. But the other thing that I find a common misunderstanding is that people think that if they don't have any independent corroborative evidence, to use a bit of legal speak, but what I mean by that is documentary evidence to support their position, like a letter or, a photograph or a screenshot or something like that, a document, that they think that if they don't have that piece of evidence, then what they say, there is no evidence of what happened. And that's not the case. because the evidence of what happens can simply be that you go to court or you go to your tribunal and you produce a witness statement, and then you give oral evidence to the judge as to what happened that day. You don't need to have a letter, screenshot, message, tweet, Snapchat proof or whatever of what you're saying has happened. So I don't want people to kind of come away from this thinking, oh, well, you know, it doesn't matter what happened. It does, but credibility is also really important. So if you're a very credible witness and you say, my name's this, you know, this is what happened on this day, then judges are very, very used to being able to assess, looking at the evidence, looking at your body language, whether or not you're telling the truth. And they can make all sorts of findings in your favor based on the oral evidence and the written evidence that you give, even if you have not a shred of what people tend to think of as evidence. But by that, I mean documentary evidence to support what you're saying.
Yeah, you know, that's so relevant. There's so many clients I have where it's like one person's word against another.
Yeah.
And then they make a finding of no finding because they can't decide. Actually, you can. And I'm going to give you an example for everybody right now. So imagine Camilla and I are in court against each other. Forget the fact that there's a recording here. And we say we're on a webinar, and forget the fact that you guys are witnesses as well. We're on a webinar at, what time is it now? Nearly 11:15. And so let's say there's no recording apart from just our word against the other. And Camilla says, yep, I was on the webinar at 11:15 with Tosh in the morning. And I'll say, no, it was at 11:15 at night. I'm a solicitor of the senior courts. I never lie. Now, who's going to be believable if it's just one person's word against the other? Now, you might think it comes down to, who knows, my qualifications, or you know, I've never done anything before. He's an honest guy, but actually, it's not enough. They look at everything in the round. Well, first of all, what was I doing at 11:15 at night? What's my story? Well, whatever my story is, it's going to be a lie, which means you're probably going to pick more holes in it. Camilla's story is really easy, isn't it? What's your story, Camilla? It's going to be, I called you last week. We set this up. I appreciate this on email.
Thanks and pleaded.
Yeah. You know, I had an appointment afterwards. I spoke to my friend about doing, you know, whatever. Yours is the truth. So it's going to be more feasible because there's just more details, isn't it?
Yeah.
So it's understanding that one person's word. So understanding that balance of probabilities, I found, is the number one issue that employers and employees have, because they're stuck on what the truth is. And I'm not saying that's not important, but what have you got to show it? Otherwise, just say anything. You know, you can't just work up and just say anything without backing it up with something. Now, that might be just the feasibility of your story, is what we're saying, right?
Yeah, absolutely. And as I said, the judges are very used to assessing people's credibility when they give oral evidence, if that's what it has to come down to, if we're in a dispute. And I like to think as well that barristers and solicitors are good at assessing credibility, because we're watching all the time. So part of what we might do before, if you know we had a client, if we were meeting them in advance, we'd see how they describe the situation that they had, and we might make an assessment as to how that account might go down in court based on how they present. I like to think that members of barristers and solicitors become the judiciary, don't they? They become judges. Yeah. So that's all those years of experience where you're practicing, that contributes towards the tribunal or a court's understanding of what the facts are, what happened.
I think I might get into this in a bit more detail at the stages where somebody would need to instruct a lawyer, but effectively, if you know the principles, like that burden of proof that we've just shared with you, if you understand what it takes to win a case, the rest of it will kind of work itself out. Obviously, we know the rules of the game, but as I say, if you know you've got what it is to back it up, then you'll be okay generally to prove your case. And I suppose, and the other thing is obviously, what is your case? You know, there's different rules for different types of situations. If you're firing somebody, there's a different rule. If it's discrimination, a claim you're defending, it's a different rule. So it's just understanding what those rules are. And sometimes maybe you don't need a lawyer all the way through something, but maybe if you get somebody early on to just tell you what the rules of the game are and then teaches you how to play it, that might be a more cost-effective solution than perhaps just, engaging somebody all the way because you don't know. And you've got choices. There's always choices.
We're in a really interesting time in law, because we now have this concept of unbundled services, don't we, where we didn't really have that before. So there's a greater acceptance towards having solicitors or barristers dip in and out of cases during the course of litigation, and courts are much more understanding that that's what happens. Whereas I feel like 20 years ago, It used to be, you have your solicitor on record, and they manage the case from start to finish, and no matter what it costs, that's kind of the expectation, is that would happen. Now I think there's a lot more flexibility. One of the good things about your firm, I know, is that you are much more flexible about that kind of thing. And so, with me as well, we try to sort of, if we make it a condition that everybody who's a client is funding it throughout at the same level, we know that it's going to be it will basically be unaffordable for certain people.
There's a question, Camilla, from Mara. Can you see that on your screen, by the way?
I can, yeah. This is really cool technology.
So Mara's question says, I would, however, emphasize that the first question a tribunal panel will ask themselves is, where is the evidence? And contemporaneous, I'll get my teeth in, contemporaneous written material is given more weight. What do you think about that, Camilla? What do you have to say about that?
Yeah, I agree, Mara. That's absolutely right. If you have contemporaneous evidence, of course, it's given more weight. I think what I'm getting at is this idea that very often, I'm thinking in particular, if we're talking about employment law, I'm thinking about discrimination cases where there is no contemporaneous evidence. If you're talking about somebody who's being bullied, there's not always a lovely document bullying somebody. And that's what I'm saying. Like, I hate the idea. People often think, oh, because I don't have, a text message to prove that this is what was said in a dark, whatever, I can't establish my case. That is not the case. But what you're saying, Mara, absolutely right. Where you've got, it depends what kind of dispute you've got. If you're talking about an unfair dismissal dispute, then I'd absolutely expect there to be contemporaneous evidence. And if there wasn't, then I'd be very suspicious. But if I'm saying that my boss inappropriately touched me in the, in the stationery cupboard at work, I don't expect there to be contemporaneous evidence of that, written evidence, I mean. So that's the distinction.
Yeah, and that makes that absolutely. We're talking about the situations, Mara, where there is no evidence for some whatever reason, and obviously in certain cases, like Camilla just said, if there's no evidence in an unfair dismissal case, that sounds alarm bells for lawyers and judges. Why wouldn't there be? So and anyway, there's certain rules that makes a dismissal fair in law, which means you probably need that sort of documentary evidence anyway, right? She's just replied saying, yes, fair point, but I would just hate anybody to think that it's not necessary to make notes. No, you're absolutely right. No. This is what we're saying. The reality is you need to have as much evidence as you can in any given situation. If somebody raises a discrimination claim, you have a grievance, don't you? And you have the details of that grievance, and you have the details of what's involved and all that sort of stuff, and you go through a proper process. If it's a situation where somebody just quit, they don't have to go through that process, and they've claimed discrimination, or the example of the stationery cupboard Camilla gave, where they just leave. Well, there's no documents. In which case, we have to. Then it's then the tribunal process that starts to create a paper trail. As lawyers, we probably end up writing to that person and say, well, what's the details of this? You never brought this up before. Why didn't you? So we're just saying there's different ways of looking at the evidence, but ultimately the principle is the same, whatever the circumstances. What have we got in all of the circumstances to support your case? That's the basic line. Right?
And we're also trying to give information. I think what we're trying to do here, I like to think, Tosh, is trying to give the viewers information that perhaps is a common misunderstanding, because I think it's kind of common knowledge that if you're dismissing somebody, you take notes. It's kind of like, we know that. It's not. I don't feel like I'm adding very much value by telling you what you probably already very, very well know. So I think that's what we're trying to give you, the sort of things that perhaps you won't get from an ACAS guide or that's right. a training.
Exactly right. I'm not looking for a textbook answer here. What we're trying to do is give you a little bit more insight.
You've got Google for that. You can Google a lot of this stuff.
Just a quick jump to the polls. So actually, it's weird. Unless just 4 people have voted, it's 25% on every single issue. So the biggest frustration: 25% say fees, 25% over lawyering, 25% lack of response, and there's 25% that say, that have said other. Put it in the chat, but I haven't seen what that is. So look, please do it in the chat so we can address those things. And I will address all 4 of those things in a moment, okay, when we get into that. So we've covered the first bit, Camilla, which is really, how do we not need a lawyer in certain circumstances? And there are shortcuts to those processes. So before we get into the next question, which is, what should people do to save time, money, and hassle early on in the process, right? I think it's a really good idea, Pat. First of all, can you give us 2 examples of your biggest types of headaches that you've seen companies experience. And I'd like it in 2 forums, if possible. One of them is in a company dispute, maybe directors or shareholders, that sort of issue. I know that comes up quite a lot.
Yeah.
And the second type of case where there's, you've seen things go quite wrong if they've not instructed earlier, if they'd instructed somebody earlier, it would have helped, is the employment tribunal. I don't mind which order there is, but can you think of a couple of examples?
Where it's gone quite wrong.
Put you on the spot now.
Yeah, no, I mean, there's so many. I tell you, that one that springs to mind in the employment tribunal is I've got quite a lot of examples of this where people have come to me where they are all of a sudden facing costs applications because they've litigated their case by themselves in a way that is not been complying with tribunal orders, not necessarily some would say misconceived arguments, and they're staring down the barrel at an application by the other side to recover thousands and thousands in costs, and that has occurred because the way that the litigation has been managed has not always been. There's been issues about breaching tribunal orders, or at least I say allegations of that. So that's one thing that I see in another forum, say like a company law dispute, where it goes horribly wrong. It's an overall thing. It's a legal point, but it's a misunderstanding of the duties that a director of a company is under, and a misunderstanding of how those duties play out. So when you're the director of a company, you owe duties to the company. You can't just serve yourself and decide, what's in your interest. You have to always put the company's interest essentially first. Yeah. And I think there's a kind of common misunderstanding I've seen play out time and time again where directors of companies don't necessarily understand how strictly the courts take those duties, and then they end up in litigation by another co-director who's saying, look, you've breached this duty, you haven't done this, and this, the other, and that it gets very nasty very quickly and quite expensive as well.
I've seen 2 types of key issues. Number one is director disputes where it's just not worked out for whatever reason, right? And somebody else wants to pick the other one out, or one of the directors are not behaving in a sensible manner, or they're misbehaving, whatever it is, what we're calling it a day, and they don't have a shareholders agreement in place, or an agreement. You know what? Because it was great, let's just do a golden handshake. Yeah, let's get on with it at the beginning. The only reason people need a lawyer is if things go wrong. And so you want to get a lawyer in early on to stop those things from going wrong. If they go wrong, we've got it covered. So I think that's one big situation I've seen with directors where they don't have something in place for an agreement. Similarly with employees and employer situations, it tends to be either the employee thinking that they've got rights that they don't have, and then the employer just doesn't know how to handle it. And actually employers have rights. Employers can be firm and employees and know what the circumstances are. It's not a case of employees beating the drum and employees doing the dance. So what I've seen is that they get involved, they get lost in this, dealing with these cases in a way where they are doing what they believe is right and wrong in the circumstances, rather than understanding what needs to be done to resolve it. And what needs to be done to resolve it is a combination of the law and psychology, actually, just understanding the way that people can think and going behind it. We don't have to get into a dispute about everything. Everything doesn't need to mean going to a law. I know that sounds like a very unlawyer-like thing to say. Some of it is a lot of psychology, understanding what to do. I think you and I have talked about these things, but I've settled a case for a box of chocolates in the past through an ACAS process and an apology, because people. Yeah, apologies are a big. A lot of employees have been wronged.
I also really want to say, because there's something I'm trying to offer something that I say to my clients that I don't hear said elsewhere. So this is what I wanted to use this opportunity to say this, is that I have noticed from a psychological perspective, there are certain flashpoints in litigation where people's mentality becomes more fixed. So it's very, very hard after certain points. It's much harder to settle a dispute, for example, after witness evidence has been produced. Because once a party has had an opportunity to think about their position, to commit it all to writing, to sign a statement of truth or some other kind of form saying that this is what happened, that each party, each witness becomes further entrenched in the correctness of their position, trying to get them to actually concede that there may be some weaknesses in their case is very, very hard after the production of witness statements. So psychologically, if I'm dealing with a dispute, if we're looking to settle it, we think there's a possibility. I try and, not just from a cost-saving perspective, but think about, okay, the moment that witness statement is produced, the chances of settlement reduce. They're not extinguished, but everybody becomes more, satisfied with their own position, more entrenched in it, and it's really hard to get compromises out of people after that.
And also, I've seen that lawyers are guilty of the same thing, Camilla.
They believe their own hype.
What Joe put in there, one of the things that not headaches or frustration with lawyers, jargon. And don't get me wrong, Joe, we even have problems with other lawyers just speaking, not in a normal way about certain things, or they need to feel intimidating in a certain way or become a certain. And I think, Camilla and my view, I know definitely it's Camilla's as well, is you don't really need to be that way if you know what you're talking about. Unless, of course, you do need to be that way because the other person's being a certain way. But you're right. What happens is people feel psychologically they're at a point of no return, or they've got to save face. With lawyers, I was saying, we'll say, my client wants this amount. If I'm representing an employee, for example, or an employer, doesn't matter which side it is, I'll talk to the other side and I'll say, this is what we want. They'll say, we're miles apart. So we'll have to, we definitely can't meet. And I said, no, we might be miles apart now, but let's just really explore it to its proper nth degree, and then we know it's really done. Because actually people just automatically assume that's the end of a certain point rather than going a bit forward. Or maybe if we realize how that employee felt, it will probably resolve the situation in a better way than getting into legal arguments. That happens with ACAS or mediation. So it's getting past the real issues and trying to get to the real issues. Why was that person really upset about?
I'm just thinking of a particular settlement agreement that you were involved in, that I became involved in, where actually what the claimant wanted was a barrister to train. Do you remember this? The directors of the company.
Yes, I do remember that. Yes, it was a tick box exercise to demonstrate something, wasn't it? Yeah,
to make sure that the directors of the company were trained on issues of the Equality Act, because the claimant felt aggrieved, I suppose. So that was a really unusual, really, to this day, I've never seen a settlement agreement that had that kind of requirement. But really interesting, and that demonstrates what you're saying, which is that sometimes it's not always about money. It's about people want to think that they're making a difference and that they're preventing the next person from going through what they went through.
Yeah, just to put that in context, what Camilla is talking about, there was a case that was settled with we were representing a company, and the settlement that the company wanted to agree to with the employee who felt that they had been discriminated against, which they hadn't, but doesn't matter. And part of the settlement was, look, I want to make sure this never happens to anybody else. So to make sure it never happens to anybody else, I want the company to agree that they will get training for all those managers that treat me a certain way by a barrister, not just an expert trainee in diversity or whatever it was.
No, it had to be a barrister.
A barrister specifically who will deal with this. And they agreed to it. So, whether it's a box of chocolates or getting a barrister to correct behaviors, you can agree anything in a settlement agreement, but it's understanding what actually motivates both parties to get involved in the court case in the first place. And actually, before we get lost in the process, then, come back and take a bit of a balcony view on it, I think is the key there, isn't it?
Yeah.
So let's move on to the next bit, Camilla, which is, look, what is the right time to engage a lawyer? I'm mixing the second and third topics, really, to save clients money, hassle, and in your experience, and time.
So I've made some notes on this, because I've been thinking this is a really difficult question. There's no one size fits all. I think that it depends on a number of factors. So I thought I'd make a list of the factors. I think when is the right time depends firstly on the complexity of proceedings. So, for example, if you have a notice pay, you're not being paid your notice pay, would I suggest that you instruct a solicitor or barrister to deal with what is potentially quite a modest amount of money maybe not at that stage, because I think that's the sort of thing that you ought to be capable of resolving yourself. Whereas if you've got a very complex whistleblowing case, I would say engage a solicitor or barrister right at the start. So complexity. Number two, how experienced you are with litigation, because there are going to be some people who have, if you're, for example, an employer and you have a lot of experience. I suspect Mara may be one of these people. I have no idea, Mara, what your background is, but you may be somebody who's got a lot of experience.
That, doesn't it?
Yeah, exactly. You seem like you know what the procedures are. And so you may feel that in your circumstances, if somebody's coming at you with an unfair dismissal claim or even discrimination, you may feel, well, actually, I'm quite capable of dealing with myself, at least up to a point. Whereas if you've got no experience, then perhaps, and it's an area of law that you're not familiar with, then you might do it sooner. Number three, I've said how much risk you're willing to accept, because there is risk associated with any kind of litigation. There's greater risks of things going wrong and you getting bad outcomes, I would say, in a situation where you are worrying, you have to consider the costs. So in the event that you make a mistake in the litigation, you could be ending up facing a cost order against you. So that might happen in a director's dispute, for example, far more likely in a county court or the High Court than you would in a tribunal. So how much risk you're willing to accept? Are you willing to risk a cost order against you, paying the other side's cost if you make a mistake? Again, number four, I've said the type of court or tribunal. Generally, if you're litigating in the High Court, you're probably going to want a solicitor or a barrister, perhaps less likely if you're dealing with the employment tribunal. I think number five, I put how determined an opponent you have. Because if you've got somebody who is really, really tricky to deal with, you may need a lawyer just because they might run rings around you, or they might just drive you absolutely bananas. What's happening now, I don't know if you see this, Tosh, is the data subject access requests. I'm seeing that in every aspect, and people are using that as an alternative to getting disclosure that they want. Sometimes
and to cause a lot of cost and inconvenience to come.
Exactly. Yeah. So sometimes, when you have a lawyer, in case people don't know, but the point of contact for that dispute becomes the lawyer. So it is inappropriate if somebody's suing you or you're in litigation with somebody for you to be contacting the person who you're against, or the company you're against directly. It's actually not appropriate in litigation terms. So what you're doing is you're putting a buffer between you and that really difficult person. So that's one thing. At what point do you engage a lawyer? If you've got somebody who's really determined and really difficult to deal with. And the last point I've said is how much time you have to dedicate to doing this stuff yourself, because it's possible. Anybody can learn anything. I'm a big fan of saying, you can, if you have 50 hours to dedicate, you can teach yourself a lot of stuff. You're not going to substitute years of experience. You're not going to get the judgment calls, I would say, that a solicitor or a barrister can have, but you can teach yourself if you really want. But it might take you 150 hours, 200 hours to do it. If you have that kind of time, you may not want to engage a lawyer until later. So those are the sort of factors. There's no one size fits all, but these are things that I think you will take into account.
Mara mentioned earlier, I saw her on there, but it seems to have gone now, but that she was an HR consultant and an ET panel member, or ET member of ET service. So that makes a lot of sense, Mara. You've got an inside knowledge then of the way that question was presented. I wanted to add something to it. So, from my experience with the right time to engage a lawyer is it's quite obvious, isn't it? It's a little bit like when you need a plumber. If you know what you're doing to a certain extent, that's fine. But also there's different ways of using that plumber, isn't there? For example, maybe you could get that plumber in for an hour to teach you how to do the job rather than 10 hours to fix the job. So as a lawyer, there's lots of clients where budget might be an issue, and then you talk to them about how to solve it themselves. You give them the recipe. Or when you get a lawyer, a lot of people do when the job has already gone bad. I guess what we're trying to say to you, we've got a crystal ball into these types of situations, is when you get a sniff of an issue, pick up the phone. You must know somebody. And if you don't know somebody, you know me, and I don't have any kind of clock, the ticking clock with the charge on it. You just give me a call and I'll happily talk you through with no obligation. So that you're in your network. If you don't already have somebody, you've got me to give a call. If you need to go to court for something, I'm going to put you in touch with Camilla anyway. And Camilla's details will go out with the replay of this if you want to speak to her directly about any issues you're facing. Genuinely, the purpose of Meeta and I setting up this forum was to provide access to experts in the industry who are wanting to put some good out there and help you. And anybody that's been with us for the last 12 months will see that we'll be doing that consistently. There's no catch. This is not some sort of a sell or anything of that sort of nature. We're genuinely putting lots of information out there, and the same goes for offline calls. So if you're dealing with those situations, let us know, okay? I think, Camilla, before we wrap this up, I just wanted to ask a couple of quick things. Let's first go back to the poll. So the poll is exactly the same. I think I'd like to address some of those things. So with fees, being a nightmare, I think the key issue is understand, one of a lot of things that clients call me, first thing they'd say is, how much do you cost? And I guess the issue might be, what's the value? So, for example, we don't do a cost as an hourly rate as such. We do fixed prices. So there's fixed price lawyers out there. There's hourly rate lawyers out there. There are no win, no fee if you're a claimant, I suppose. And you know what a lot of companies may not know is you'll have access to a lawyer or access to legal fees being covered if you end up going to court on the back of some sort of contents insurance policy that you might have within the business. So lots of people don't know that. It doesn't have to cost you something. But, fees do not have to be an issue. And obviously it's subject to what your budget is, but don't not have the conversation. You can say no to the lawyer. Whether it's an hourly rate, a lawyer's they've got an obligation to give you a fee estimate. And if it's a quote, well, then it's a quote. So that's certainly it. Over lawyering was the second category, lack of communication. Well, I think there's two things with that. What's your view on that, Camilla, first of all?
Yeah, I see a lot of complaints from often, actually, I'm afraid to say, but solicitors, the clients who've had direct relationships with solicitors. I'm sorry, Tosh, but who come to me, not Tosh. Like, Tosh is very communicative, but when they say, oh, we've tried to get, we've got passed from pillar to post, so we've instructed Mr. Smith, but then we got passed on to Mr. Brown, and then sometimes Mr. Brown was away on annual leave, and then they get kind of pushed around, and then there's gaps in the communication, and the people don't really know what's going on. It's a delicate balance because you don't want a lawyer to be constantly communicating with you, billing you, for example, to say, oh, by the way, I'm just letting you know there's been no updates on your case. That's and then charging you for that. But at the same time, you want to feel that you want to have an idea of where your case is. So I think that's one of the things I've heard from my clients.
And you know what? It's your choice to pick the lawyer. If it doesn't feel right, if they don't sound right, don't sit there thinking that they're the expert and you've got to do what they say. That you're their client. So if they're, and also, they've got to get the resolution. It's not about just lawyering. It's not just about the law. It's about getting the solution for you, whatever that means. So if the fit doesn't seem right in terms of lack of communication or whatever, the deal is this. It definitely is the rule in the way that Camilla and I will operate, is this is what's happening now and this is what's happening next. So at any moment, you as a client should know what is happening in your case and when you should next expect to hear from the lawyer, unless, of course, you want to go back to them for some other reason. So you should always know what's happening now, what's happening next, and also they should be telling you what they're doing for you and why. It's not just a case of listen to the expert. The third category was a lack of response. So, look, lawyers can be busy, but if that is a problem, tell them. Tell them what kind of, agree the form of communication with your lawyer. We've got, for example, I don't know whether you have this, Camilla, we've got WhatsApp. So clients will contact us by WhatsApp if they can't get through to me on the phone because they realize I'm on the phone with other people. And we promise to get back to them. And getting back to them might be, can't talk to you right now, give me a couple of hours. They realize you've got a life if it's outside of hours, and they realize you're dealing with other people as well. And, it's just called life. But it is about managing expectations. Have you noticed that as well?
Yeah, well, so I'm really careful about this in my business. So we have a reception obviously manned, but we also have a number of practice managers who you can speak to, and because obviously I'm in and out of court a lot. So but we don't allow the phone to be it's a real priority that we make sure the phones are answered, that emails are responded to, even if it's not directly me, but somebody on my behalf will do that. We're really careful about that. And we log every email very carefully so that we put it in a case. So even with clients where they haven't engaged to instruct us, we basically set up sort of systems so that we manage their communications to make sure they're not left hanging.
Exactly right. And so if you're feeling that frustration with the solicitor you're dealing with, agree the lines of communication with them, whatever those mediums are, emails, phone calls, what your expectations are, and they can tell you whether they can meet them or not. And the last one was other, which people, I know that Joe put in jargon, and you're absolutely right. You know what, if they're talking, if you don't understand what they're talking about, they're probably not the right person for you. And look around, come talk to me. I can, whatever your area of law is, even if it's not employment law, I'll know somebody that can help you. So I'll definitely put you in
same. So we between us, we know quite a lot of lawyers in different areas, different specialisms, and that's right. And generally, my experience is if you can't explain something simply, or at least if your lawyer can't explain something simply in a way that you can understand, and you're of a reasonable intelligence, then it might just be that the lawyer isn't actually very good, because it's part of the skill of being a solicitor or a barrister or a lawyer, just to be inclusive. But it's part of their skill set and training to try and be able to explain complex ideas in a simple way. So it just may be that they just don't have the right experience that would benefit you. So shop around, essentially, I would say.
I'm running out of time, but I do want to just add a couple of quick bits as well, which is, when you're speaking to a lawyer, if you're choosing a certain type of lawyer, understand that they've got to have good listening skills. They've got to be responsive. They've got to understand what your actual desired outcomes are more than perhaps you do. It isn't just about winning a case. Success means different things to different people. Might not be money. Might just be getting rid of a case. You can lose an unfair dismissal case and it not cost you any money, for example. So just understand that the fit has got to be right, and you can shop around for these things. You're not obligated to pick one person, but what you do have is access to us, who can put you in touch with the right people if you need to. So I hope that helps everybody. Camilla, thank you so much for participating. Oh, sorry, yes.
I was going to say, just on that note, that think about things that, particularly because of COVID-19 and the effect that it's having on litigation across the board, that if you choose, you could be in a relationship with your lawyer for a long time. I mean, when I say a long time, you could be 12, 18, 24 months. Some of the cases that I've been involved in have lasted 3 to 4 years. So not necessarily an employment tribunal, but just to give you an example. So think about it as a long term. Is this somebody you're happy to spend time with on the phone, in person? Do you get on with them? Because that is an important, from the quality of your life, you want to have somebody that you have a good relationship with, that can, last the distance of what could be it could be a lengthy process. It could be quite unpleasant at times. So pick somebody you get on with.
Camilla, thank you so much for participating in this today. Camilla's an absolutely lovely human being, fantastic barrister. So I happily recommend you to her if you want to be in touch, if you're dealing with something right now. Everybody, thank you very much for watching. I hope you found it useful, and I'll see you back again next week with Meeta back in the chair, and have a great week. Take care, everybody. Bye-bye.
Bye.